Okay, hello, everybody. Good afternoon. Welcome to the webinar, Fortifying Against Data Breaches, Legal and Technical Strategies. Thanks for attending, and if you have questions during the presentation, please feel free to put those in the chat, and we'll get to those at the end. Let me do a quick introduction of the speakers. Trish is a chair of the cybersecurity and privacy practice at Carlton Fields, which is a very respected company that here in Miami and other locations around the country. She's a cybersecurity and privacy litigator who advises clients on privacy issues and artificial intelligence. And as you can see from the slide, in addition to being an attorney, she has several coveted information security certifications, just like many people here at our cybersecurity firm. Celia Hernandez is a cybersecurity blogger, and wish her congratulations. She just graduated from Stetson University School of Law last week. She has been blogging about cybersecurity and laws and regulations and following them closely. She is a judicial intern in the Middle District of Florida. She is a published author, and she's currently deep in studies for the bar and has plans to join a Tampa law firm. Colin works here with me at ERM Protect Cybersecurity in Coral Gables. We are a full-service cybersecurity firm. We do all kinds of assignments as listed here under Colin's resume. Penetration testing, IT risk assessments, digital forensics, and Colin in particular is an expert in cryptocurrency fraud and has actually helped put a couple people in jail. Colin is currently a fifth-year student, PhD student at the University of Miami, and he is researching AI applications, blockchain, and cybersecurity. Important slide here, you'll want to note this. I will send this recording out afterward. This is eligible for CLEs from the Florida Bar. This is the course number that you're going to want to cite, 2404357N, and is in NED to get your 2 credits. And briefly, the agenda, each speaker is going to be about 15 minutes. Trish, the lawyer, of course, will be, since she's defending a lot of companies that have data breaches, she's going to talk about ways to reduce your data breach liability. Sally's going to talk about an important bill that passed the Florida legislature that's expected to be signed and has actually already been implemented in other states that gives safe harbor to businesses that follow certain cybersecurity standards. And then Colin, who of course is very technical, he's going to explain how to comply with some of these frameworks and standards that would extend safe harbor to you, but beyond that are just prudent anyway. So with that, I'm going to turn it over to Trish.
Wonderful. Thank you, Judy. If you can go ahead and start to the next slide, we'll jump right into it. Thanks for joining, everyone. Happy to be with you. So I will be speaking about basically how to reduce your cyber exposure, but from a lawyer's perspective, right? So I will leave the technical to Colin later, but on the front end, what's the first thing you can do? And that's prepare, right? We need good policies in place. And what do I mean by good policies? Well, one, we want them clear, right? We don't want them to be twisted, and we can actually go back one, Judy. Yeah, we don't want them to be twisted and leave a lot of room to be used against you, right? We do, though, want to, what I call, leave room for life, which means it's best typically to avoid statements like, thou shalt, right? Thou will do this, you will do this, because you don't know the full facts of the situation. And typically you need some leeway there, right? So what you want to do is include phrases that are more like consider, and then put in different factors. If you come down hard on something and you say that you're going to do it, and then you look at the facts and you're like, you know what, that's just not the right thing to do in this situation, you are going to be in a position of explaining why you didn't follow the policy that you put in place. So, okay, so you didn't think about that clearly before you had your policy, or no, you set up that policy because you thought that was the best approach, right? Right. But you didn't follow that policy in this instance, did you? No. Right. And so you want to avoid that playing out in court. The other thing in your policies is that you don't want to overpromise. So I remember over a decade ago at this point, when the cloud was more of a novel concept, there were advertisements that you'd hear on NPR, and it'd be something like, and you're 100% secure in the cloud. And it was that moment, I remember the first time I heard it and I gasped aloud. I went, oh, because I knew they were going to be sued. Right. And so what you want to be careful of when you are, say, in your privacy policy, for example, is stating things where people feel like, you know what, you've overpromised. And when something goes wrong, you know those statements will be used against you. Also, you want to check the implementation of those policies, right? Because what you don't want is to have this one policy, and then it turns out no one's been following it and you haven't been enforcing it at all. So address those things. Good policies that we follow, definitely a way to reduce risk. Another big area is vendor management. And this has been a focus more and more of regulators as we've seen increasing number of breaches at vendors that have then dominoed through industries, right? So one thing is just before you enter into the contract, right? Actually doing due diligence on who's going to be holding your data. Next, having those solid contract terms in place that give you the ability and the oversight over that vendor, right? Auditing rights, having indemnification provisions in place in case of a data breach, right? Okay, what happens? Who's going to pay for that? And typically you want indemnification, but you also want to pay attention to having a provision to fund that indemnification, right? And that's where insurance comes in, because you not only want that they're going to be responsible for paying those costs that you might incur, but you're going to want to look at, okay, and if they just go out of business, where are you going to be able to get those funds from? And that's where insurance comes into it. And of course, the battle over, well, are they actually going to tell you about that breach? How quickly? And the negotiations around there. Also, data minimization, right? You can't get compromised for data you don't have. So to the extent that you don't have, say, a ton of social security numbers laying around, that is very helpful for them not having to address all the notification obligations and credit monitoring obligations that can come up when that information is potentially compromised. Also, when you think about, say, terms of use, right? A big exposure, costly area in a data breach can come from the ensuing class actions that happen. So if in your terms you have arbitration provisions and class action waivers, what that basically says is, look, we're going to make it right by this individual consumer, but we're not signing ourselves up for a massive class action where, you know, the plaintiff's firm is going to get millions in fees and, you know, the individuals will get their like $1.25, right? So taking a look at what agreements you have in place on the front end for how you're going to handle disputes. Next, insuring appropriately, right? I can tell you, I have seen this take many different approaches. I have seen people obviously very frustrated by how much their cyber insurance premiums have risen. I have also seen companies who said, you know what, I made it a sticking point that we have cyber insurance and it covered us when we had a breach and we didn't have all these expenses that we would have had in that instance. And then finally, when you're preparing, think about what you are doing now as preparing a story for what happens in case of a breach, right? So you want to work you're putting in to your cybersecurity program. And then once you finish preparing, you should, Judy, if you go to the next slide, that's right, prepare some more. So we're going to want to refresh your data maps, right? If you know where you keep your data, what type of data is in that location, that can spare you a lot of time when you're looking at an incident and thinking about, hey, what type of data was there? What was potentially compromised? What are my notification obligations, right? So having a sense of where you have your data, how much of it, what kind, is very helpful in allowing you to respond well when an incident does occur. having risk assessments done, right? Because then you know, okay, well, what types of risk are associated with a compromise of that particular system, right? What protections do I have in place there? And really looking at, okay, how do I want to protect that data, given the data map and where I know of the type of data and how much of it there is, what protections do I put in place? And then revisiting your security program regularly, right? Things change. The laws change quickly. The way we do business changes. So we want to make sure that we are refreshing regularly so that we are, providing the correct assessments and responding to the latest risks. Also, testing and training, right? So testing is especially effective when it's done by someone exterior, right? Because there's just more credibility in that, look, we had a separate third party come in. It wasn't us taking a look at our systems and saying, yeah, we think that's great. We're doing fantastic, right? It's when someone exterior actually takes a look and says, look, we reviewed, here's what we found. And then with training, people obviously are one of the largest vulnerabilities, right? You are only as strong as the most gullible individual at your organization. You can think of their name right now. That is how strong your cyber program is, right? Because it only takes that one person clicking a link to create a huge problem for your company, right? And then taking a look at actually having a rehearsed incident response plan, hugely important, right? Because the Ponemon Institute did a study of large breaches, and they found that actually having a rehearsed incident response plan typically saves about $1 million in these breaches, right? So it's just good business to have that incident response plan in place and to really consider strongly doing that. What does it mean that you have that in place? One, that it's updated and it fits your organization, right? And how you're doing business. It has a team. Who's going to evaluate these incidents? Who's going to respond so that it isn't the situation where a breach occurs and everybody's looking around thinking, okay, who's in charge here? Who do I need to talk to, right? Having a contact list included in there. So it's not just, all right, here's the team and it's just a list of email addresses, but hey, turns out all email is down from this incident, right? We need different ways to reach out to these people and get in touch with them, actual cell phone numbers, things like that. I will tell you that sometimes you run into like the high up executive who doesn't want their cell phone number listed in the policy, right? That's okay. Just make sure that, the other people have their cell phone number and one of them at least has the cell phone number of the person who doesn't want their cell phone on that contact list. And then circling back to my earlier point, when it comes to, okay, leaving room for life, again, have phrases like consider, and then the factors that you are going to consider so that you don't end up having an incident response plan that then gets used against you when you decide, you know what, for this particular instance, we aren't going to do what we typically do. Why? Because there's a reason, and your policy or plan has left room for that. Next, having backups. I will tell you, I've handled breaches for companies who have had backups and companies who have not. And you can really see the difference there, particularly with one, the amount of leverage that the threat actors have to say, you will pay me this ransom, but also in just how disruptive it is to the business and how quickly they can get up and running, right? So I had two healthcare entities in the same week once, both with ransomware hit them. One of them was down for less than a day, didn't even, and barely phased relatively for a breach, and the other was down for over a week. So the value of these backups is huge, right? Next, knowing your contractual commitments and requirements. So play this forward. Imagine a breach occurs and you're going to call a lawyer and you're going to ask, okay, so what are our notification obligations? And we'll helpfully be like, well, from a legal perspective, here's the type of things you're dealing with. Regulatory perspective, here's what you're dealing with. And then there's those contracts. And that's typically where people sort of pause and think like contracts. Where are our contracts? What do those say? Right. And so having a handle on what type of contractual commitments you've placed on yourself in those contracts that you have with, say, your business partners That's huge. And those timeframes can often be very short, right? Many times in those contracts, you're looking at, say, 48 hours or as soon as possible, no longer than sometimes 24 or 72. I think 48 is really the most common that you come across. But that comes up very, very quickly when you're dealing with a breach and all the other aspects that you're trying to deal with. So having a handle on the front end on what are the contractual commitments you've made to your business partners is really valuable. The other thing I'll point out is oftentimes you'll have I'll see clients who have a lot of alerts set up. They're doing a lot of monitoring, right? And that's great. It is better when those alerts are being reviewed and not just making noise. So for example, what sometimes happens is client will get very excited about this new tool. It's setting up lots of alerts, but they're being alerted to so many things that it just turns into noise and it's not pulling out what's most important, right? So you want to make sure that monitoring is happening and that there's an action based upon it, right? So oftentimes, the bad guys like to ruin weekends and they see less attention being paid on weekends. Particularly holiday weekends. I always brace myself for holiday weekends because it is a favorite among cyber criminals. And they just hop into the system and start wreaking havoc. And if you don't have someone monitoring those alerts and acting upon them, then what you end up with is just a mess when everybody comes back to the office and there's this, say malware's been like propagating throughout your system or something like that, right? So the importance of really having the monitoring in place and reviewing to it can be hugely helpful in, say, stopping the bleed in a data breach. Judy, next slide, please. All right, so what happens, what sort of preparations do we put in place when we're actually responding to a breach, and how can that help reduce liability? Well, one is just maximizing privilege, right? This is, I think, one of the key areas where outside counsel comes in, right? I mean, I work with a lot of clients who are really sophisticated, like they know how they handle a breach, right? But they often use outside counsel to maximize privilege. And so many of you on the line likely already know this, but the really important part there is, okay, you want your outside counsel to retain that forensic vendor. And that vendor then doing the analysis is doing that analysis so that your counsel can provide legal advice, right? And so you structure the contract that way in order to have that assistance for your attorney to tell you what your obligations are. And that way you can comply with the law as opposed to just a forensic vendor who's out purely working in like this business component where everything they're creating is then just going to become an exhibit in a potential litigation against you that's identified this vulnerability and what happened. One really important thing there that no one ever likes is, so you've had this forensic firm, it's created this report to help your outside counsel, right? But then it turns out that like 20 different people at your company want to see that forensic report because they think it'd be really valuable to know some things, or they're just curious, right? You do not want to overshare that forensic report. Reason being that even if it were privileged to begin with, if you start sharing it too broadly, you're going to waive the protection. So you went through all that effort to get that to be privileged. If you just start sharing it too broadly, you're going to lose that protection. So avoid that. Don't overshare the forensic report. Next, how to reduce liability when you're responding to a breach. One, you want to make sure you're meeting those reporting obligations, right? Both on the timing and on the content. The biggest mistake I will point to, so oftentimes, even if we are not handling a breach, we'll be functioning as shadow counsel. In other words, someone's using their insurance company's panel counsel, but they want someone looking out for their interests and as opposed to their, being paid by the insurance company. So they'll hire us as sort of a double check. And the biggest correction that I make to drafts that I see in those instances is typically for accuracy, particularly where oftentimes there's this favorite phrase of like, we have no indication that your information was actually compromised or something along those lines. That is a problem if, the threat actor had screenshots of this particular person's information in what they have provided when they're trying to shake you down for a ransom. right? So really being very focused on what do we know in this particular instance, and does that align with what we're stating? Because sometimes you'll see this temptation to paint things as not as bad or not as certain as they are. And you really have to avoid that if you don't want to risk a regulator turning around or plaintiffs turning around and saying, you lied on the notification you gave me. You didn't notify me the way you were supposed to. And you know what? I think it's an unfair trade practice, what you've done. So want to avoid that. Being accurate, important. Next, being aware of evidence creation, right? We don't have to be creating every little piece of evidence. And so you want to avoid situations where you have, say, the IT person who wants to start writing large soliloquies in email about how I always said this would be a problem. I never thought our cybersecurity was adequate. That's why I wanted us to use this tool, and going on and on and on. Obviously wanting to avoid those kinds of things, but also preserving evidence, right? We don't want to create extra bad evidence, but we also don't want to destroy any evidence and then risk spoliation claims. So what that basically is where the plaintiff turns to you and said, you deleted that information, right? And that information may have provided important insights into what you were doing right or wrong, right? And create this inference against you that basically says, because you destroyed that evidence, I get the jury assume that you did that because it was bad stuff in there that you didn't want coming into this trial. And finally, when you're responding to the breach, another thing to keep in mind is just documenting the timeline of what you knew when. It can be very easy for plaintiffs to point out and say, well, you didn't do this, you didn't do X, and you didn't do Y. And it's very helpful if you have that timeline to look and say, well, that's right, and here's why, right? It's because we were under this impression of the facts at that time, because these facts develop very quickly. Here's what we knew at the time, and here are all the efforts that we were doing to address this incident. And next slide. Awesome. And then when it gets to litigation, right? This is pretty simple. If they are bringing some claims, you want to attack the elements and make sure they've actually established those claims. If they are alleging a HIPAA violation, you want to actually say, well, HIPAA doesn't have a private right of action. So is there, you can't just bring that. And this varies by jurisdiction. Some jurisdictions will let you take something like a HIPAA violation that doesn't have a private right of action and squeeze it into a negligence claim. But there are other jurisdictions that say, no, when HIPAA didn't have a private right of action, it meant it. And you can't just portray a HIPAA violation as a negligence claim. Attacking standing. This is a huge area in breach litigation, which is basically this idea of, well, can you sue for that? Do you have the ability to sue? And a big issue in data breach litigation, particularly, is whether the person has been harmed. Or so let's say their information was compromised, but there hasn't been any showing of misuse. Have they been harmed yet so that they can sue? Or is it really just that they may be harmed in the future, in which case, okay, well, then maybe they sue then, but not now. Class certification, another big area, right? So data breach class actions actually get certified into class actions about half as often as most other class actions. So that is a very important sort of intersection in a breach litigation, where we want to point out the issues with class certification and why this particular instance may not be a good fit for class certification. Another huge area for breach litigation, though, is safe harbors, and I'm going to let Saley speak to that point.
Thank you, Trish. That was really excellent. That tracks with a lot of the issues we see when handling data breaches. So now Saley is going to talk about HB 473, which also known as the Safe Harbor Act, and just a little bit about general regulatory trends that we're seeing in cybersecurity. Saley, go ahead, take it away.
Thank you, Trish and Judy, and thank you everyone for joining. We can go right ahead, Judy, if you want to. Yep. So I'm here, like Judy said, to talk about Florida House Bill 473, which was just recently passed in the Senate in March 5th after being introduced this past November. So it moved relatively quickly through the legislature, and it has not passed yet. It is still waiting Governor DeSantis's approval. Generally, this House bill is going to provide local governments in Florida and Florida businesses, as well as third-party agents working with businesses, a safe harbor for any litigation for cybersecurity suits, if they comply with certain regulatory frameworks, which I will touch on right now. So these are the standards specifically for businesses. So local governments in Florida have a specific standard that they have to meet instead of the first one that I will talk about. But Florida businesses, in order to enjoy this proposed safe harbor, must first substantially, which I will talk about what that means just in a little bit, comply with the notice protocols required under Florida Statute 501.171. Excuse me. So this statute generally requires that covered entities in Florida provide notice of any breach of security to the Florida Department of Legal Affairs if there was a breach of security affecting 500 or more customers, and they must do so immediately after they discovered that breach or within 30 days. And generally, it also requires that the business inform the individuals whose information was affected. So that's the first part of this safe harbor, complying with this specific notice protocol. And again, this is specific to Florida businesses. And then the second part, and really the main part of this, is complying with one of the following recognized standards. And I won't get too much into depth because Colin will explain what this all means in just a little bit, but it pretty much requires or incentivizes companies to follow one of these recognized standards to further protect themselves against a breach. So what does the law do? So this proposed law is going to apply to tort claims only, and we are mainly all familiar with negligence, so that would be something that would apply under this law. And it is important to note that, just like Trish said, the private right of action thing is very, very specific. So this proposed bill would not have a private right of action, and instead it works as an affirmative defense that local governments or businesses could take advantage of, meaning that you or I would not be able to sue a company under this bill for the company's lack of security. Instead, the company would be able to plead this as an affirmative defense and tell the courts, hey, I complied with this law. I should be protected from any sort of litigation or costs. And again, following the same lines, failure to comply with this proposed bill once it passes is not evidence that the business or the local government acted negligently. Again, it's just a defense that they could use. So what is going to be the impact of this bill? So in the latest summary analysis, as this was going through the Florida legislature, the Florida Judicial Committee obviously thinks this is a good idea. Excuse me. They are hoping to strengthen cybersecurity in Florida by providing governments from protection from expensive litigation if they meet these requirements. Sorry. On the other hand, attorneys such as Trish might be a little bit more jaded. So specifically for what does substantially complying mean? The legislature left this undefined, and maybe for a good reason, but I'm sure plaintiff attorneys will probably fight for months and maybe even years as to what substantially means and whether a company or a local government substantially complied as opposed to regularly complying. So this might actually run afoul of what sorry, of what the goals of this bill is, by actually making litigation more costly instead of reducing these costs, because like I said, attorneys will just fight over what this really means instead of just providing the businesses or the government's protection from litigation costs. Now, there are some trends in the US regarding making sure security is more stringent. So in New York, they have this cyber regulation, which is arguably the most strict in the entire country, and it applies specifically to financial institutions. So they just recently amended this regulation to make it even more strict. And now they require a plethora of things, including annual penetration testing, password policies, increase responsibilities for CISOs, a business continuity and incident response plan, and even more strict requirements for bigger companies that make more money in the state of New York. Likewise, House Bill 473 follows into the footsteps of other statutes that have safe harbors for companies. Ohio was the first one. Excuse me. Ohio was the first one, and their safe harbor bill was enacted in 2018. And following Ohio was actually Utah, which expanded this protection to cover non-tort claims and actually allowed plaintiffs to allege that a business was delayed in responding to a breach of security. So it really broadened this this immunity, while Connecticut in 2021 also excuse me, narrowed this protection by eliminating punitive damages by eliminating punitive damages unless the entity acted grossly negligent. Now, Florida is arguably providing the broadest immunity. As we all know, we have a reputation for being very business friendly. So this bill is very broad in the immunity that it provides to Florida businesses in order to protect themselves from these expensive litigation costs, as Trish mentioned. So what now? So like I said, the bill is not law yet, but Governor DeSantis is expected to sign the bill. Excuse me, is expected to sign the bill. Unlike New York, like I mentioned, who has a very strict cybersecurity law, this House bill does not have a minimum standard that all entities must meet. Instead, like I said, it just provides businesses, governments, and third-party agents with an incentive to comply with cyber standards. The minimum standard, like I said, might be not too business friendly here in Florida, so maybe that's why it hasn't been done yet. But merely this House bill just provides protection for these entities. Now, while the bill is not law yet, it is important that businesses take proactive steps to maintain a robust cybersecurity program. In the event that it passes, which it likely will, while there are some issues that I highlighted, it is always good to have a robust cybersecurity program, not only to protect yourself in the event that this passes, but also to protect customers. And that is all. Thank you, Judy.
Judy, you're muted.
So great. Thank you, Sally, for fighting your way through that despite having the flu. She appeared today. I will try to send out the recording, but listening to you talk reminded me that Sally has written two really excellent articles, one on HB 473 and one on the amendments to the New York law. And I'll try to see if I can send those out as well. Okay, now we're going to turn to Colin, who's going to talk to us about, well, what is the NIST framework? What is it? What do I have to do to comply with it to earn this safe harbor?
Excellent. Thank you, Judy. So to lead into this, we first need to discuss who is NIST. So NIST is the National Institute of Standards and Technology, and they're part of the US Department of Commerce. They're a world leader in creating critical measurement solutions and promoting standards. Specifically, they create a set of cybersecurity standards. One of these cybersecurity standards that they've released is called the NIST Cybersecurity Framework, which is a framework that aims to help businesses of all sizes reduce their cybersecurity risk and protect their networks and data. The NIST Cybersecurity Framework was recently updated in February of this year, and it's a flexible IT security framework intended to be tailored for use by all organizations, regardless of size and current cybersecurity maturity level. To make cybersecurity accessible to everyone, NIST breaks down cybersecurity into 6 top-level functions. These are govern, identify, protect, detect, respond, and recover. Each of these functions have control categories, and each of the control categories have subcategories. So remember, a control is something that we have in place to ensure our cybersecurity. For example, we'll have a password policy that says passwords need to be reset every 90 days. That's an example of a control. So again, NIST breaks down cybersecurity into 6 core functions. Govern, for establishing and monitoring cybersecurity risk management strategy, expectations, and policies. Identify, which contains controls for determining the current cybersecurity risk. Protect, which is the group of controls used for safeguards to prevent or reduce cybersecurity risk. The detect function has controls to find and analyze possible cybersecurity attacks and compromises. The respond function has controls related to taking action regarding a detected cybersecurity incident. And finally, the recover function contains controls related to restoring assets and operations that were impacted by a cybersecurity incident. I'm now going to provide a brief 1-minute summary of each of these functions so that we have the background necessary to understand what's needed to comply with the NIST framework. I promise once I get through this background, we can look at the technical steps needed to comply with NIST. Again, detailed information for each of these functions is in the slides, which we'll provide following this webinar. So the first function we want to look at is the govern function, which is related to establishing and monitoring cybersecurity risk strategy across our organization. One of the most important things that the govern function asks of organizations is that cybersecurity be part of your DNA. It shouldn't be a side note. It should be a main focus of the organization. We need to understand risk, not just by our IT security team, but at the highest levels of our organization and upper management. We need to ensure that everyone in the organization understands their role in overall cybersecurity. This means creating and communicating good, clear cybersecurity policies across the entire organization. We need to perform oversight to ensure that we don't just talk the talk, but we also walk the walk, that all of our policies are actually being enforced. And lastly, we need to ensure that not just people within our organization, but any third-party vendors that we use are also following our cybersecurity practices. The identify function contains controls related to determining the current cybersecurity risk. This starts by performing asset management so that we know what we're trying to protect. When we do asset management, we're not just trying to find all of our hardware and software, but we also need to identify any systems, facilities, services, and people that need to be included in our cybersecurity program. Once we've identified our assets, we're ready to perform a risk assessment, which allows us to identify the cyber risks to our organization and to those assets that we've just identified. The identify function also requires us to do continuous improvements to our cybersecurity program so that we evolve with the evolving threat landscape. The protect function focuses on safeguards to prevent or reduce cybersecurity risk. This includes having a well thought out and enforced identity management, authentication, and access control policy, as well as performing awareness and training, taking data security seriously, performing platform security, which includes recording any logs and ensuring the confidentiality, integrity, and availability of all of our platforms. And lastly, performing technology infrastructure resilience. For example, when the COVID-19 pandemic hit and organizations had to switch from being in person to remote, all of those controls for doing that in a secure manner would fall under the technology infrastructure resilience program. The next function is the detect function, which focuses on finding and analyzing possible compromises. Obviously, we need to be doing continuous monitoring, not just of our hardware and software, but we also need to monitor our networks, any physical, any personnel activity, and importantly, we need to monitor our third-party access to our systems. In the event that a security incident is found, we need to perform adverse event analysis to understand what that event is and escalate it if needed. The respond function contains controls related to taking action against those detected events. Importantly, the respond function has the management category, which is where our incident response plan falls. This is where we need to understand how we're going to contain, eradicate, and recover from any detected incident. It's also important that we communicate with our internal and external stakeholders during this function and be ready to mitigate any of the events that we find. Lastly, after responding to an incident, we're ready to recover from that incident. The recover function contains controls related to restoring assets and operations. During the recover function, this is where we're going to execute the recovery phase of our incident response plan and any disaster recovery plan that we have. Again, just like in response, the recover function emphasizes communicating with all internal and external stakeholders as we recover from an incident. So as Saley mentioned, there's lots of different frameworks out there that we can go and comply with. And the NIST cybersecurity framework is just a general overview. Each of these are going to have their own specific intricacies as we try to comply with them. So how do we go about complying with one of these frameworks? So the first step of a process is selecting a framework that best meets your industry and your needs. So for example, if you're in critical infrastructure, you're probably going to want to comply with the NIST cybersecurity framework for critical infrastructure. After we've identified what we want to comply with, we need to perform what's known as a gap analysis. During a gap analysis, we identify all of the controls our organization already has in place and identify what controls need to be added in order to comply with our selected framework. After we've identified all of the gaps, it's up to the IT security team to implement controls and new policies to cover the gaps identified. Once we've finished a gap analysis and remediated any gaps identified, we're ready to perform a full framework audit to verify that all of the necessary controls are in place and ensure that all of these controls are being enforced regularly to ensure compliance with our framework. Ideally, this should be done annually and by an independent third party. You don't want to have your IT team checking their own work. So how do we actually go about complying with these controls? So for the governance section of the NIST cybersecurity framework, we want to perform annual policy and procedure review, refine, and design to ensure that we have all the correct policies in place. This involves rereading all of our policies and procedures and ensuring that we're following those policies and procedures and making any changes to those policies and procedures as threats evolve. We may even find that we need to write new policies and procedures as new technologies are released. For example, a lot of companies recently have had to write new AI security policies so that their users understand how they're allowed to use AI within the organization. For the identify function, we should be performing annual security configuration reviews of all of our critical devices. These are reviews where we check the settings of all of our critical network devices, such as our firewalls. So for example, we might look at our firewall rules and see that we're allowing traffic from all countries to connect to our network. Some organizations may want to make that stricter and instead say only traffic from within the United States can connect to this country. We also want to perform annual risk assessments where we identify risk to our environment. For example, we might identify we have some servers located here in Miami, and we might notice, well, one risk to those servers is a ransomware attack taking over. We would then identify what's the probability of a ransomware attack to those servers, and we would identify mitigating controls that would help us prevent or recover from a ransomware attack. For example, we might have antivirus software installed on those servers, and we might be performing regular offline backups to mitigate the impact of a ransomware attack. For the protect function, we want to undergo annual internal and external penetration testing to verify that all of our security controls are functioning as intended. A penetration test is when a security expert attempts to breach a network using the same techniques that a malicious actor would do, and then recording the techniques that were successful so that the organization can learn from that attack and increase their security. We also want to provide security awareness training to our employees annually, where we have our employees sit down and listen to a lecture or go through a PowerPoint, learning the basics of security and the types of threats we'll face. We also want to follow up our security awareness training with phishing exercises, where we actually send employees phishing emails and let them click on it and record who's interacting with those phishing emails so that we can improve our training with our employees. For the detect function, we want to perform annual red team assessments to ensure that our detection tools are configured properly. A red team assessment is an advanced form of pen testing where we can really go in depth in all of the different kinds of techniques a real hacker would use. For the respond function, we want to perform annual tabletop exercises, which are exercises intended to simulate an attack, but over a tabletop. During these, we'd invite all members of the organization, so the IT security team, upper management, HR, legal, so that everyone can be involved in this simulated exercise. This helps cross-team communication and ensures that everyone in the organization understands what their role would be in a real exercise. Lastly, in the recover phase, we want to perform post-incident digital forensics, where a forensics analyst comes in and identifies the root cause of any incident and what might have happened after the initial indicator of compromise. So again, to summarize, these are all services that ERM Protect provides. We want to be performing annual pen testing. We want to be performing security awareness training. We want to make sure we're compliant with our chosen frameworks and do regular audits to ensure that compliance. We need to perform digital forensics following an incident. And we need to do comprehensive security assessments to ensure that all of our current security practices meet industry best standards.
Great, thank you. Thank you, Colin. We did a good job on timing too, so I'm going to get to a couple of questions here. This one I think would be for Trish. It says contracts with core system providers are difficult to amend, particularly their master agreements. Do you have any suggestions on how to negotiate?
Yeah, obviously you're going to use whatever leverage you have, but that can sometimes be limited. For example, Microsoft doesn't do a whole lot of negotiating with a lot of companies, right? Or it can depend how much business you're getting, how big the other player is. So you obviously have to consider the leverage that you have. If you have more leverage, that's always easier to negotiate from, right? But what I find helpful is often getting into the why. Because a lot of these areas, one, you might be dealing with something where the other side understands why you are requesting something, right? Or there's an increasing number of laws that actually require specific provisions in order to comply with the law. So what I often do is put in a little comment bubble. So I'll put my adjustment that I want, and I'll put in a little comment bubble, a citation to the law that I am addressing, right? Because in that way, I'm explaining that I am making this change to protect us both because we both want to comply with the law here. Now, in some areas, the law isn't clear. And so you are sort of looking at, okay, well, is it going to be 24 hours? Is it going to be 72 hours that you're going to notify me, right? Point to the fact that like, okay, well, we as a business have to report to our regulator within, say, these 72 hours. So we need to hear from you at least within 48, or explaining why I want to know about even suspected incidents before they're confirmed. And so for me, take advantage of any negotiating power that you have, of course, leverage what you have, but always explain the why and frame it as this protects both of us. And here's realistically what the law requires. If you are uncomfortable with that, why? What do you suggest that can still meet this requirement? So focus on the why.
This is probably for you as well, although I think anyone on the panel could answer this. Does the new HB 473, if signed, supersede other state and GDPR requirements? Trish, do you want to take that?
Yeah, it's so I'm not sure I'm agreeing with the framing of the question. But when it comes to like GDPR requirements, there's nothing really that's inconsistent there with what the GDPR would require. So I'm not sure I'm understanding the question well enough. It certainly doesn't state that it's going to have to supersede.
I don't think it
Um,
supersedes that, but Colin, you and I just talked about this the other day. We talked about mapping people who already comply with GLBA and FSMA. So if we were doing an assessment, I think this is how we would handle this issue. Go ahead, Colin.
Yeah, so if you were already compliant with things like GDPR, FSMA, HIPAA, all those other security frameworks, we can perform what's called a control mapping, where we identify the controls covered in GDPR, HIPAA, whatever your original framework is, and map those to what other framework you want to comply with. So if you want to comply with one of those frameworks in the list, we can do a control mapping. I imagine if you're compliant with one of those, you're probably 90% compliant with one of the other frameworks. And then we can add in, do a gap analysis to identify what controls you need to add in so that you're completely compliant with the other frameworks.
Agreed on that. I will just, my caution is in framing these things as frameworks that often they don't have a whole lot of specifics, right? So definitely agree with overlaying the requirements, figuring out where the gaps are, and then addressing from there, definitely.
Okay, Saley, are there any unintended consequences of HB 473 that we should be aware of?
Yeah, so I think Trish and I both kind of touched on this. The fact that maybe it might have unintended consequences, and the fact that people would just fight over what substantial compliance means, and other specifics of the law that may actually make litigation more costly as opposed to reduce costs for businesses. I think that's one of the main one, and probably the one that affects businesses the most, because really this law is trying to help businesses out in providing them protection from this expensive litigation, as Trish said, class actions and stuff like that. So that might be an unintended circumstance. The fact that they really did not define what substantial means, which again is probably for a good reason, but that might have a unintended consequence in that sense.
Trish, what do you think?
Agreed, right? I mean, basically they've recognized that there's a problem and they're trying to come up with a solution, but that necessarily involves some flexibility. And I have never had a plaintiff's firm who found that anything was sufficient, right? I mean, regulators, when you're dealing with them, they'll investigate and then drop claims if they find that, you know what, no, you were all right, you were taking reasonable steps here. But I have never had a plaintiff's counsel in a data breach class action come up and after discovery say, you know what, you spent millions last year, that was sufficient, you were reasonable. Has never happened, and I don't think it ever will.
Right.
So sorry to fulfill what Saley said about attorneys being jaded.
Okay, Colin, can my internal IT staff handle implementation of the framework?
Yeah, so a lot of these controls can be done internally. The one thing you want to be careful of is the people implementing controls should not be the people checking to see if the controls are implemented, right? You need to make sure you have some independence there. So yes, your IT team can do a lot of these things internally, but it's always recommended to have an independent third party come and take a look just to make sure things are as they should be.
Okay, and Trish, what is the cyber litigation landscape looking like? Are things getting better or worse?
Yeah, I mean, I'm encouraged by the fact that we have legislation like these safe harbors. I should mention that Tennessee also has one that is even a bit more aggressive than Florida's, and they've passed that. So they've recognized the problem, but realistically, what we're seeing is more and more on a regulatory front. So increased reporting obligations, increased specificity, oftentimes in particular cyber measures that regulators want to see. And anytime you increase the amount that you're either increasing specificity of what you want in place, or just increasing reporting of incidents, you necessarily and I doubt that that is going to be counteracted sufficiently by these types of safe harbors. So more jaded attorneys.
Colin, how do I decide which framework to follow? Is there one that's sort of industry standard?
Yeah, so we chose to talk about the NIST cybersecurity framework because it's the most general of the frameworks. But different industries are going to have different frameworks that they should follow. So for example, we were talking about GLBA, FACTA, FISMA earlier. Those are all great for banks. But if you're not a bank, you're not going to want to comply with the banking ones. Or if you're in critical infrastructure, right? If you're a water treatment plant, you're going to want to follow the cybersecurity framework for critical infrastructure. So it's knowing your industry and knowing which one of those frameworks best meets what your industry requires.
Okay, let me see how we're doing on time here. I think we're about ready to close up. I will send out the PowerPoint. And I'll also, let me go back to find the course number here, because I know a lot of people, there you go. So this is the CLE number you want to cite to get your CLE credits. And again, I'll send out a recording, and I will try to also fish out Saley's excellent article on the HP 473 and the new New York amendments to the New York regulation, which, you know, that has more to do with, you know, who has to report data breaches and other things. But I was stunned by the number of the kinds of entities that are now covered by that regulation, which Saley, correct me if I'm wrong, but it was like basically check cashing companies, mortgage brokers, wealth management
correct, yeah.
firms. I mean, it
Very
was
broad.
a stunningly long list of companies that and it's not just headquartered in New York. It's like if you're doing business in New York, right, Saley?
Right.
So
Yeah.
if
Very
I'm a
broad.
bank, if I'm a bank in Miami and I have a US operation, not a bank, or a business in Miami that has an office in New York, I'll have to comply, correct?
Correct.
Okay, great. Well, everybody, thank you for joining us.